Great, guys. So we're coming to our last presentation of the day. That's going to be Verena Griffiths. We're going to talk about the whole notion of copyright. Verena, are you there?
I am, Adam. Good morning. Can you see me? Can you hear me?
Good morning. Good afternoon. Just within
Afternoon.
4 minutes. Yes, I can see you very clearly. One or two things about Verena. If I can just grab my notes here. She is a trademark attorney and partner at Adams & Adams, one of the leading trademark legal firms in this country. She qualified more than 15 years ago, and she has an LLM in intellectual property law. She is being recognized as a WIPR leader in 2022 and ranked in the top 1000 WTR. She's also a contributor and co-author to the 2017 edition of Copyright Chapter in the Copyright Chapter in the Law of South Africa. Publication as a guest lecturer in both LLB and LLM courses in intellectual property at the University of Pretoria. And she's quoted extensively in the media and printed as well as electronic for her expertise in this specific field. Verena, we're now dealing with this beast of AI and ChatGPT. Can you give us some more guidelines when it comes to copyright? Who owns it, and what are the rights, and where are the pitfalls?
I can only try. Let me share my screen. Let me know if you can see it, please.
Perfect. Thank you very much.
Great. So, yes, good afternoon, everyone, and thank you for joining, either staying or joining this particular session and allowing me the opportunity to share some of my thoughts around copyright and AI. As I was listening to the presentations earlier today, they were all fantastic. I had this thought of a quote by the very inspiring Willy Wonka that goes something like, never doubt that which no one is sure about. And I thought that was quite apt for the subject matter that we are discussing today. But let me get into what I will be discussing in particular, which is the interplay between AI-generated content and copyright. Now, I want to start by pausing at the question, why? Why are we even talking about copyright in relation to content that is produced by generative AI? And in order to unpack that question, we need to understand what it is that copyright does. And that is simply that it entitles its owner, the copyright proprietor, to control the use of copyrighted material, right? So in order to deal with any copyrighted material in a certain way, such as reproducing it, adapting it, publishing it, one needs the consent of the copyright owner. And it is in exchange for that consent that the copyright owner is in a position to request and be entitled to some gain or benefit. Typically, that would be a financial benefit. So if I take a simple example of a novel, say, the proprietor of the copyright in a novel can grant publishing rights, it can grant translation rights, it can grant rights to turn that novel into a manuscript for a film. So there are all these avenues that are potential transactions to generate income. So it's really that ability to exploit copyrighted material exclusively for commercial gain that is important, and that depends on owning the copyright. Now, if we consider that, by way of example, things like computer programs, mobile applications are also protected by copyright. The ability to exploit them commercially in the form of licensing against payment, for instance, depend on owning the copyright. It becomes evident that the value of copyright ownership could be quite significant. And this is where the answer to the question surrounding the subsistence of copyright in AI-generated content becomes relevant. It's really in two respects. Firstly, whether copyright can subsist in AI-generated content at all. And then secondly, if copyright protection does extend to content created by AI, who owns those rights? Because they directly translate into the ability to commercialize. Before I can hone in on copyright in AI-generated content specifically, I do want to just take a step back and touch on what copyright protects more traditionally, which are creations of the human mind. So a human author's intellectual creations, where a human produces something, whether through creativity, technical skill, intelligence, research, development, simply crafting something with our hands. That which is produced would typically qualify for copyright protection. We refer to those results of human efforts as works in terms of or under copyright law. And the Copyright Act specifically lists which types of works are capable of protection. Those works include what are referred to as author's works, which are the more traditional product, let's call it, of human intellect or creativity. So the literary works, the artistic works, and the musical works. Those works tend to have a close personal connection to their author. Literary works, for instance, include novels, as well as stories or poems, but also speeches and letters, reports, and even tables and compilations. Artistic works, on the other hand, include photographs and paintings, drawings. Those would include drawings of a technical nature, as well as works of architecture. And it's important to know that literary or artistic quality is not a requirement for copyright to vest. It is merely the production of a work that can be categorized in terms of the Act as one that is capable of protection. Now, copyright does not only extend to the more traditional author's works, but also to works of a more technical nature, as I mentioned, computer programs, and things like sound recordings and cinematograph films. Now, something else that is important to understand when it comes to copyright is that it comes into existence automatically. If a work qualifies, the moment it is created, it will be protected. An important distinction to be drawn is the fact that copyright does not protect the concept or the idea behind the work, but it's only the embodiment or the material form in which that work exists that would be protected. And then last but not least, for purposes of this discussion, one of the most important requirements for copyright to vest is that the work must have been original in its making. And what that means is not that the work must be new. We do not require novelty under copyright law. Originality in terms of copyright means that the work was created through the author's own skill, effort, expertise, creativity, or labor. In other words, the author expended of his or her own skill to such an extent that the end result justifies the protection, bearing in mind that that protection really comes down to a monopoly. So in summary then, a human produces something that can be classified as a copyright work. It will be automatically protected the moment it is created, provided that the author expended sufficient own skill and effort. So what happens with the use of artificial intelligence, of course, is that the human creator is replaced by the technology. So the starting point, therefore, flies in the face of what copyright is traditionally intended to protect, or so it seems at least. And it is here that many of the debates have their origin, in particular with the question whether these works that are created by the AI should be protected at all because of the absence of a human author. In the US, for example, the Copyright Office there came out very strongly with a view that where there is no human author involved, there can be no copyright protection for the material concerned. The same holds true for Australia, and the jury is out in many European jurisdictions. So it seems, at least currently, there is a notable, and I'd even go so far as to say, deep discomfort in granting copyright protection to works that have not been created by humans, or at least where no humans have been involved at some level in terms of authorship. Having said that, the results that are produced by this technology are typically things that would qualify as works eligible for copyright protection. So if we refrain from dismissing protection out of hand because there is no human author, and we accept that the material produced is capable of copyright protection, the question, at least in the South African context, should turn on the issue of originality. Now, you will remember that originality is measured against the author's skill and effort, and it may appear as though we have now come full circle. We arrive back at the point where we have no human author to look to. But in the South African Copyright Act, there are two aspects that go some way in assisting us with where to look for an answer. The answer is certainly at this point not conclusive, but these provisions definitely do assist us. And the first of that is that our Act provides specifically for works that have been computer generated. And our Supreme Court of Appeal has already held in an older case that involved computer software that these are works, in other words, computer generated works are works that have no human authors. So far, so good. There's recognition for the fact that works that are created without any human involvement are capable of copyright protection in South Africa. But we're back to the question of how do we determine originality? And in this regard, the Act again assists us by defining who the author of a computer-generated work is. And that is the person who made the arrangements necessary for the creation of the work. This leads to one of two options of who may be the author of computer-generated works. And that is either the person responsible for the creation of the AI program, in other words, typically the developers, or the person providing the instructions to the program. And that would be, of course, the user. Now here, an interesting conundrum arises because without the development of the AI, the subject matter created by the AI could never have come into existence. The developers certainly made arrangements that were necessary for the creation of the work, if I reference strictly the wording of the Act. However, the developers, of course, had no intention of creating the particular work in question, nor did they play any part in the creation of that result. AI generates subject matter by making independent decisions. The results that are generated by AI are not fixed. They cannot be predicted. They cannot even be expected by the developers. And the work's existence really depends in the first instance on something that is conceptualized by the user. So the proximity of the developers of the AI to the end result, the work in question, really complicates the argument for its authorship. And that gives rise to the alternative, which is that the user could be considered the author. So that would be the person or the persons who provide the instructions. And bear in mind that with conversational platforms like ChatGPT, those users are even in a position to provide follow-up questions or improve instructions, to challenge a premise or make a suggestion and so forth, and thereby having a little more input into arriving at the end result. So we have these two possibilities, either the creator of the AI or the user thereof, as potential options of the authors. Either way, the requirement of originality will still have to be satisfied under South African law. And it would have to be showed that what was done entailed sufficient skill or knowledge or effort on the part of the author to justify the protection. And that really becomes a factual question, especially when it comes to the argument in favor of the user as the author. One would really have to interrogate closely what was done in the creation process. There certainly is a difference between providing a simple text prompt for the creation of an artistic image versus the development of, say, a mobile application, with the input of a team of creators who respond to the AI, engage with it and insist it to correct or improve the end result. I'm not necessarily saying that that would be sufficient, but the importance lies in the distinction. There is a difference, and there is a requirement for an assessment on a sort of case-by-case basis. So assuming then that it is possible for a work generated by AI to qualify for copyright protection, and that we can identify an author, and that we can get to a point of originality, the obvious next question then is, who owns those rights? And here too, the author is relevant to answering the question, because the Copyright Act provides that the author will be the first owner of copyright, except if one of a finite list of exceptions apply. And one of those exceptions is where the author is employed and the work is created in the course and scope of such employment. This is a statutory provision, and it does not depend on the employment contract. So you do not necessarily need that provision to be in the employment contract. The Act provides for that exception to apply, and the copyright ownership shifts automatically to the employer. So that means where an employee uses generative AI to complete any task that falls within his or her scope of employment, to the extent that the end product can be protected by copyright, and again arguing in favor of the user as being the author, and assuming that the threshold of originality can be met, copyright would vest and those rights would be owned by the employer. However, all of these questions remain at this point unanswered, untested even, and certainly uncertain. So apart from my opinion, I cannot really give you a conclusive indication of what the outcome of such an assessment locally would be. And I think it would very much depend on the particular set of facts and evidence that is placed before the court at the time. That being said, most, if not all, of the AI platforms have contractual terms in place when you engage with it, which intend to manage rights such as copyright. For instance, OpenAI's terms state that those rights are transferred to the user, and I'm talking copyright specifically, transferred to the user of the program. So thereby seemingly attempting to circumvent, to an extent at least, the issue in question. That, however, by no means guarantees ownership under South African law, and no one should necessarily feel comfortable that what has been created can be exploited commercially to the exclusion of others, which is really going back to the rationale of having copyright protection, that ownership is important in order for the ability to commercialize. Other platforms, depending on the circumstances, at best provide for a license in favor of the user over the material produced, which means that the developers in those circumstances, their intention certainly is to retain any potential copyright ownership. Many platforms also contain, as part of their contractual terms, an acknowledgement by the user that the program may very well create the same or a very similar end result for another user. So too, that the AI will be allowed to use that which has been created as a basis to create for others. So it seems as though it can almost be accepted that exclusivity will never be guaranteed. And it would be necessary for that reason to really consider the commercial value or the potential value of that which is being created or intended to be created using generative AI before the decision is taken to do so, because of the requirement of the ability to commercialize the end result, which will not be the case in each and every instance where these technologies are applied, of course, but certainly still relevant to where that would be the intended end result. In closing, I want to turn back to the US for a moment, and admittedly, our copyright legislation is different to that of the US. But a recent case study may very well illustrate where this may be headed. So in the United States, copyright can be registered, and it is the US Copyright Office that receives these applications for registration, and it then assesses the works for registrability. So it comments on whether a work can qualify for protection or not. And you may remember that I mentioned to you that the office's initial response to AI-generated content was simply and quite strongly that in the absence of a human author, there can be no copyright. So the office then received an application for the registration of copyright in a comic book entitled Zarya of the Dawn, for which the artworks were created by the author of the book using Midjourney, which is a generative AI program that creates images from text prompts. She did create the text and the layout herself, but it was the artworks that she had employed the AI platform. So she applied for registration, and she sought registration over all of those, the text and the layout, so the published edition, but also wanted recognition and registration for the fact that she is the owner of the copyright in the artworks created using Midjourney. Now, in her application for registration, she explained how she had created these artistic works. And she naturally provided the text prompts as a first step, and she referred to that as the creative input. And then from the results that she would receive back from the AI platform, she would then choose one to develop further, still using the AI. So she would change the prompt to keep generating images until she got something that she was happy with. She described that as a trial and error exercise, and said that she had provided hundreds, if not thousands, of descriptive prompts. And it was only once she was sort of happy with the end result that she then chose an image. And then she went one step further. She took that image and she edited them using Photoshop. Now, these are the examples taken from the evidence that she had lodged with the office in terms of what it looked like before and after she employed Photoshop. The Copyright Office was not convinced of the author's case. It held that Midjourney was not a tool that she controlled or guided to reach a desired image. It acknowledged sort of how AI works in that it generates images in an unpredictable way, and the text prompt really does not dictate the end result, or any specific result for that matter. Instead, there is a significant distance between what a user may direct a program like Midjourney to create and the visual material that it actually produces. And, you know, having played around with these myself quite a bit, I'm often surprised at what returns after having inputted a certain text prompt. Which just goes to show that there is very little in terms of the ability to dictate what the end result may be. The Copyright Office actually equated it to providing an artist with a general instruction to create a specific image, where in those circumstances, the person providing the instruction would definitely not be considered the author, right? It's rather the artist who receives the instructions and then determines how best to express them that will be the author of the artistic work. It was interesting to listen earlier to Professor Osman when he explained that the AI, as much as it can write or debug code, it does not necessarily understand the code. You know, it uses what it has learned to rewrite. So it illustrates to me that sort of distance between the input and the end result, which does make it difficult to bring it back to authorship and originality. In the Zarya case, the office was willing to acknowledge and register the copyright in the text and in the published edition, which is just the layout of the book in its entirety, but not in the artistic images that were created using Midjourney. So bringing that back to the local context, we may ultimately see an outcome that could be aligned with the result of Zarya, But it will, as I mentioned, certainly be dictated by the facts and the evidence of any particular matter. Right now, as I see it, and as I see the law, and I see this technology developing, and at the pace at which it is happening, and all of the uncertainties around it, my personal view is that businesses, any commercial entities, should be very careful to consider the application of generative AI where it is intended to create an end result, where the value of that result would be determined by the ability to own the IP. If it would be important to own the copyright in that which has been produced or is intended to be produced, the use of these technologies should be approached with a lot of caution, given all of the uncertainties and question marks, serious question marks over subsistence of copyright in the first place, and secondly, the issue of ownership. So Professor Rosman started this morning with a cliche of getting ChatGPT to generate a title. I'm incidentally concluding with a credit to DALL-E for all of the imagery used in my presentation. Thank you again for the opportunity.
Thank you so much, Verena. Fascinating case that you dealt with there.
I think so.
Gosh, I'm sure you will agree with me that it's absolutely a privilege to, like we've seen the whole day, to see a real professional in action. Thank you for a very insightful presentation. I just want to see quickly whether we have, right. So Dixon says, so does it not look at AI as the tool like a paintbrush, but the hand that moves the brush is the artist, not the company that made the paintbrush? Maybe we should ask ChatGPT what it thinks about that.
Yeah, exactly. The difficulty lies, I almost think that it would have been easier to answer the question if we handled it like a tool. The difficulty lies in the fact that the difficulty and the benefits really in the fact that we have this definition for computer generated works. There is a meaning attached to it, and we can slot the AI technology squarely into that definition. And then, because we have that category of work, it has its own author, and we have to sort of go through the motion and apply those legal principles to the specific work created. So it's not as easy as saying I have an artist and a paintbrush, which is just the tool to get to the end result.
Rena, I suppose, look, we're in amongst others in the publishing field as well, and our people, apart from that, when they research a topic to pursue as a conference or for research purposes, we're very diligent in referencing where you got your material from and so on and so on. So I suppose that at least you will have to reference, like you did there with that image and right at the end, where you used AI as a tool, or as a tool to come up with ideas or images or whatever.
Look, from a copyright perspective, yes and no. I think it's always good practice. And I think it's more a question of informing any reader or user of the origin of the content, especially considering that some of the content may not always be accurate. It's to my mind, that is more a question of informing than it is a strictly speaking copyright infringement consideration, which yes, otherwise be the consideration in referencing where the material came from, properly quoting or crediting.
That's a very fair comment. I just want to see whether there's anything else. Yeah. Okay, guys, you have 1 minute still to post a question or make a comment. Tap the brain of one of the country's top copyright intellectual property specialists. If you want to make contact with Verena, by the way, you can go on the Adams website, and her details is there to utilize professional services. Now, I think, I think people have heard a lot today, and maybe I have to reflect on it still before they post anything else. I think in closing today, Verena, by the way, sorry, I'm just going to wrap up now. Verena, thank you very much for your input today. I really appreciate that. And let me just see here, Louise de Beer. What about the copyright of the data that these models have been trained on? Oh, that's interesting.
There's a reason I did not go into that. That's another half an hour on its own. And my personal views, again, a whole lot of question marks there. Already there has been a case that has been launched by Getty Images. I forget now if it's I feel like somewhere in Europe or the UK maybe, against one of these generative AI platforms that create artistic works. And the allegation there is simply that their database has been scraped, by allowing these tools to sort of go out and gather as much information as they can in order to learn. Part of that process involved scraping existing databases. And if you look at the evidence that Getty has put forward in substantiating that case, it's quite alarming to see. I know that we were told earlier that the AI platforms create new content. They're not simply reproducing, and that is true to a large extent. But if you look at what Getty has put forward in terms of what has been generated by this artistic generative AI platform versus what is existing on theirs, you can clearly see the similarities. You can even on some of them see the Getty watermark pulling through, which begs the question, because that is where we get into dangerous territory, where we are simply reproducing or even adapting. And when I say we, I'm talking the technology, where an act of reproduction or adaptation is taking place from an existing work. That's where we move into the risk area for copyright infringement. So I wouldn't want to answer that conclusively right now, but certainly that is a very interesting consideration in terms of how content is generated. And of course, what is the liability then for commercial enterprises, businesses, employers, allowing the use of these tools in generating content that they would want to exploit commercially, put out into the market. If that could potentially constitute an infringement of copyright, you could be opening yourself up to some serious liability.
Okay. Super, thanks. Yeah, so that brings us, guys, with that comment at the end of today. But I need to share this with you. I read yesterday, it was an article that published in the latest Economist, and amongst other things, they make the point that actually, in terms of the fact that everything is there on the internet, your whole persona through social media and so on, that in future you might not even die, that your family, relatives and other people can still have a conversation with you and ask you a question around to whatever, that because that information is there out there. And it gave me a lot of comfort that my vast rugby knowledge would not go lost for my own family generations to come. So there is still a lot that's going on in this specific field, I have to say that. I just want to check quickly, Verena, you and Dirk, I see still here. How do governments go about ensuring that AI tools are compliant to their country's laws and regulations?
I can start. I think, where's my camera? I can turn that on again. How do I do that? Oh, there we go. Do it. There we go. I think it's an interesting question, because obviously there's lots of different regulations from a compliance perspective when it comes to different countries. I think someone did touch on GDPR and obviously POPI here in South Africa. Now, I mean, I also do a lot of work in data governance for organizations, not just cybersecurity, but POPI for itself, how fantastic would it be to have an AI model that I can ask my organization and say, looking at my data landscape, looking at the technology that I've deployed to protect PII, for example, how am I faring against my regulation. How you know, am I being compliant against POPI, for example? I think POPI in South Africa is a hot topic, and it remains to be. Are we compliant against POPI? There's no tool, there's no magic button that says, you know, check, am I compliant? So if the auditors come in, I can go, yay, here's my certificate, my rubber stamp, I'm compliant. There is no such tool. However, I do work with certain tools that can give some of that answers, but I think it would be fantastic one day to look at AI and go, can you do that? Can you answer the question, am I compliant against a particular regulation? Do I have the necessary technology to protect sensitive data? Talking about data loss prevention capabilities. So I think it's difficult. Every country's got so many different regulations. I had a look the other day in terms of what Microsoft has to offer against technology complying with those regulations. And the list is this long. I mean, South Africa, we only have a few. GDPR is just, I know that's a whole different level. And I think that the challenge is there's organizations in South Africa that not only needs to adhere to POPI, but because they've got a global footprint, GDPR is something that they need to be compliant as well. So I don't know what AI is going to do in that space. It'll be great. I don't know, Marina, what do you think?
I think it's a very difficult question. If you know, how do governments ensure? I think you perhaps touching on a very good answer there, which is, you know, the employment of AI to play a role in that space. I think that probably more regulation is necessary, and that's always a difficult one because, you know, in terms of government's responsibility, that's always a difficult one because of the pace with which these things, you know, when we're talking legislation, the pace with which it moves and the ability to adapt, and that's so slow. It's almost, currently as I sit here, I feel like it's impractical given the pace at which the technology is moving. So I'm not sure, to be honest, what the answer is there.
Okay, if I can give my penny's worth, I saw the 3,000 guys that I referred to earlier this morning that Professor Benjamin also said he's a signature to. They claim in that piece of work, they say, or that letter, that the world has basically 6 months to really come out with the necessary regulations to safeguard humanity, so to speak, against the adverse impact, possible adverse impact of AI. So yesterday I read an article and they said there are basically 3 categories of views on regulations. The one is the UK's route, which is a very light touch. Then you have on the opposite spectrum, far opposite, China, where every AI company has to register their AI tools, and it has to conform to a number of criteria. Amongst others, it should support the values of China. And now read the Communist Party, obviously. And then in between, you have the European Union, which is going almost the regulation of medicine, so to speak, or drugs, that route, where you have to very clearly outline, these are the draft regulations that published, we have to clearly outline any dangers that the AI might have. The way you develop the algorithms and how it's operating and so on. The danger is, like, I mean, the CEO of OpenAI says they're not too sure what's happening there with ChatGPT 4 in the inner workings anymore. So, and now the thing is continuously learning. So in any case, I think this is a very, as Jacques has mentioned, this is very reactionary in the end, you know.
I also think, Vlalem, if I can add to that, I mean, listening to you speak, Marina, I think there's a, you know, us as humans, from maybe from a law perspective, you know, when you steal something, it's wrong. All right, it's black and white, and we as humans are comfortable in knowing that there's, I mean, copyright as an example. You know, if you're the author of a book, you own the, I mean, not knowing much about that, but if you can prove you wrote the book, you own the copyright to that content, I would imagine. And that's black and white. And with AI, I mean, Marina, you mentioned It could be the developers, it could be the users. It could be this country looking at it this way, it could be that country looking at it that way. So there's no black and white. And I think that's what scares people, is the fact that when it comes to copyright things and laws around you know, who can and who cannot do certain things with AI, I think that's what scares us, is the fact that there is no black and white, and there's no a court case that we could all reference globally and go, well, they said that is the case, and therefore that's going to become the international law when it comes to AI generated content. And that's scary. That's really scary for us. I mean, I don't know if we even had such cases in South Africa yet, which probably not. And I'm sure it's going to come at some point. So the question is, how are we going to deal with it? What are we going to decide? So yeah, it's that unknowns, I think, that scares us the most.
Definitely, spot on.
Okay, guys, I think what we've learned today is that we're only starting the conversation around AI and the impact on humanity, so to speak. I've noticed that a couple of people are also calling for maybe a United Nations, like in the United Nations a body that can oversee and regulate AI. But nevertheless, I hope that everybody, thanks again, Dirk and Verena, I appreciate your staying on.